Um, let's wait for 3 more minutes for folks to come in. Yeah. Yeah, and can you let me share the screen before? Oh, actually,
yeah, let me stop sharing.
Yeah, actually, I can do it.
Take it back over.
Yeah.
All right.
Awesome.
Okay, good.
So is your firm gonna consider keep doing remote work after the pandemic or going back to the office?
Let me see here. I just so I'm putting on my AirPods to see if this is any better. I've never done this on Zoom. Okay. Can you guys hear me okay?
Yeah. Anyone else having problems?
I think it's okay.
Okay.
Yeah, we should be good.
Is that better?
Yeah.
No, I can't hear you.
Oh, really?
Why is it that way? Yeah, but can you hear me?
Yeah, we can hear you.
Okay, so for some reason when I go to AirPod, okay, you're not getting any feedback?
A little bit, but not too serious.
Is that better?
Yeah.
Okay, so I think, say something now.
Yeah, can you hear us?
Perfect. Now I got it. All right, we're ready to go. Okay, is that cleaner? Is that better?
Yeah, a little bit.
Okay, all right. I hope it lasts.
Great. Let's see. Okay, so I will start. Welcome back. Hope you guys had a good weekend. And this is week 9, and today we're gonna cover legal things within the startup ecosystem. And before that, I'll go over the agenda. Like usual, we will have logistics and then speaker presentation and then Q&A at the very end. Again, please turn on your camera if possible. And then the legal assignment is due this Sunday, and then the final project is due next Monday. And then I'll share the quiz code after my part. Moving forward, so next class will be our last class of the semester, because we wanted to end the class before Thanksgiving so you guys can have a good break and study for finals and stuff. So we will have a mini demo day next Monday, and then we've already selected 10 out of 17 groups to present in demo day. And then during the demo day, you will have at a maximum of 4 minutes to present. And then our judges will give feedbacks in the next 5 minutes following your presentation. So if your group is selected, you need to make sure that at least 2 of your members show up on demo day on time and to present. And then the second thing would be sign up for a time slot on the sign up sheet, and the link is in the announcement in B courses. So go check it out. And then again, no Berkeley time on demo day, and then attendance will be taken at 6 p.m. sharp. So make sure whoever that's gonna present show up on time. And then 4 minutes for each group, and then more details, you guys just go check it out on B courses. Great. So if your group is not selected, it doesn't mean anything. It's just maybe your deck is not that developed yet. And also we have limited time during the class. So keep working on your project. There's nothing wrong with it. And then just make sure you gather the entire group, like gather everyone in your group and present on Zoom or whatever, and then upload your recording on Google Drive and share it with us. Again, more instructions are in B courses, so go check it out if you have any questions before you email us. Yeah, and I will change the access so that you guys can sign up. Again, then quiz code will be demo day. That will be the code to access your quiz. That's gonna do that is due this Sunday. So that's my part. With that being said, let's welcome Sam Angus, the partner in corporate and venture capital group at Fenwick and West. Back to you, Sam.
Okay. I assume we just share my screen here. Great, thank you. I assume everyone can hear me okay? Thumbs up, maybe? Awesome. All right, thank you, Summer. I'm gonna be looking to you to keep me on track here. So thanks everyone for your time. I'm unfortunately can't be there in person this year due to the COVID as we're all sort of struggling with this. But it is a very interesting time for startups and entrepreneurs in technology. I think it's actually a really great time to be an entrepreneur, believe it or not. These periods of disruption create a lot of opportunities, and that's what we're going to talk a little bit about. As Thomas said, I'm a partner in the corporate and venture capital group. That means as a lawyer, I do things like helping companies form, advise founders on founder-related issues and stock issues, help companies raise money, help companies sell themselves, and advise on IPOs and other types of transactions, SPAC transactions, and so forth. What we're talking about here is really early stage companies. And I want to focus on some of the top kind of issues to think about when you're starting a company that can create complexity and problems later on. If you hear screaming with small children in the background, I apologize for that, but that's just my family here. And again, another consequence of COVID and working at home. Don't mind it, they're fine. Don't worry about my kids. So let's maybe start, and let me just say this: if anyone has any questions, please either raise your hand or send me a chat, and we can answer it sort of going real time. A lot of this stuff is intuitive, but some of it isn't intuitive. So any question is fine. So first thing, failure to form your legal entity or the right legal entity for your startup. As I think most of you know, startups operate generally as a corporation. That is what most investors like to invest in. Why form a legal entity? Well, that creates, one, a limitation of liability to the founders, but it also creates a vehicle for which to put IP and ownership and divide ownership among the founders. This sort of spells out at a high level what the reasons are for forming an entity. One, I mentioned limited liability to protect the founders from claims and liability associated with their business. Protect the company with respect to IP and ownership of technology, and to deal with, if a founder was to leave. Without a legal entity, all of these things are ambiguous. The other big reason is to allocate ownership interests among the founders and investors and employees. And so what an entity does, it's almost like a pie, and you divide up the pie. The more efficient you are with your company, meaning the more capital efficient, and the faster you scale, the less you need to divide up that pie, and the more that's left over for the founders. So I'll pause there for a second. The next big issue when it comes to sort of early stage companies is when to form the entity. You and your co-founders have an idea early on. You may be working for another company. You may just be thinking about developing something, or you may actually be in development. I always like to advise founders to form the entity early when you really start to develop some valuable IP. Until that entity is formed, oftentimes there's ambiguity around who owns what percentage of the company, who owns the IP. There's a lot of questions. And so what you want to do by forming the entity, you want to define what all of those terms are and have them reflected in a set of corporate documents. And so my general advice is form the company early when you're starting to get traction on development, when you're starting to enter into contracts on behalf of the enterprise with respect to other parties, when you start to dole out equity to other founders or even employees, or that's the time to form the entity. There's also an issue, a tax issue that can arise with founders, that if you don't form the entity early and you go ahead and you develop a valuable business and then you form the entity, that can be tax disadvantageous, because most of the time founders will buy the shares that they're being issued in their startup for a very low or nominal amount of money. Usually it's, a hundredth or a thousandth of a penny a share. That's supposed to equal the fair market value of the company on the date you buy those shares. And if the company is basically a shell, nothing's been developed, you can take the position that share is only worth a thousandth of a penny. But I've had clients who have waited to found the company until they have actually developed something of significant value, have customers, some of them may have even generated revenue. And at that point, it gets much more difficult to argue that the company is only worth a thousandth of a penny. So that's, and what's the con? If you end up buying your shares for example, for a thousandth of a penny, but what the shares you're actually getting are actually worth much more than that, the difference is taxable to the founders as compensation. This is a similar issue, and let me just move on here. This is a similar issue to what comes up when you get a term sheet very early on for financing of a company when the company has just been formed. It's the same issue. Usually the founders have bought their shares for a very low price, and then an investor comes in and puts a value on the company. So that's another situation where, because of the proximity of the financing to the formation of the company, there can create some tax issues. As I mentioned, there are different types of legal entities you can use to start your business. Limited liability companies, I'm sure called LLCs. These are tax-like partnerships, meaning that all losses and revenues flow through to the owners. It's as if the entity, for tax purposes, doesn't exist, but for liability purposes does exist. So it still protects you from liability, but for tax purposes, all profits and losses flow through to the founders. Sometimes that can be advantageous to founders from a tax perspective, but for most technology companies, it's a vehicle that isn't used. You see it a lot used for restaurants or dry cleaning companies or closely held family businesses. Most technology companies and venture-backed companies are corporations. Corporation is considered a separate taxable entity, which won't, in the near term at least, really matter because most corporations, most early stage companies will run losses for a long time. It has limited liability, as we talked about. It's relatively simple to form. An LLC can be simple to form, but there's also, an LLC is much more flexible in terms of how to align ownership and economic interests. Most venture capitalists, however, prefer to invest in corporations, and many are prohibited from investing in pass-through tax entities like LLCs. So I will pause there to see if there are any. Let's see here, am I getting? Let's see. Okay. Second big issue that comes up all the time is to make sure that your company, your early stage company, owns all the IP it has been developed or is using. Key issue. When you go and raise money with an investor, one of the first things they will confirm through due diligence is IP ownership. And that is something that when you form the company, you want to make sure that all of your founders and early employees and advisors have signed invention assignment agreements to assign any IP that they're developing on behalf of the company to the company. If you're an employee, under state law, there's a concept called work for hire. It's a concept that says that if you're an employee and you're working for a company, under the law, any copyrights that you develop while working for that company are owned by the company. You technically don't need a written agreement to assign over copyrights, although we still advise you get invention assignment and confidentiality agreements from all of your employees. If you're a contractor, that work for hire doctrine does not apply. And I've had clients where they formed the company, but early on they used a lot of independent contractors to develop their technology, but they didn't have adequate assignments of technology. And so that created an issue where you have to now go back to those people who may be long gone and ask them for an assignment of IP. And if that is in the context of a financing or in the context of an acquisition of your company, that's going to cost you some money to get more often than not. So that's one big issue. The other big issue that comes up related to IP is IP that may be owned or disputed as owned by prior employers. If you started a company while working for a different employer, you need to ensure that your old employer doesn't have any IP ownerships or claims over your new company. This is a situation where if you leave or you develop IP while you're an employee of your old company, and you probably have signed an agreement that says any work you do for that while you're employed by that old company is owned by the old company, that creates an issue if you're developing new company IP where the old company could claim an interest in that IP. Now, if you're doing that, and oftentimes a lot of companies are started while entrepreneurs are working for an employer, you need to make sure that A, you're not using the old company resources. What does that mean? Old company computer, old company email. Don't use their email system or any equipment of your current employer. Don't do any work on your employer's time. And make sure that what you're doing doesn't relate to your employer's business. Oftentimes it doesn't. This comes up as a diligence issue when you've started your new company, you've left your old employer, you're talking with investors, and the investors, as a part of their due diligence, will ask questions about what you were doing when you started the company, who did you work for before, and if there's overlap, they're gonna want to understand very clearly that there's no basis for your old employer to claim ownership over the IP that you've developed for the new company. So that's going to be, you need to turn square corners when you're thinking about starting the company and you're working for another employer. And oftentimes I have this conversation with entrepreneurs where they agonize, well, I don't really want to quit my old job yet because the new company isn't quite ready for prime time. And this is always a tricky, set of circumstances to navigate. And you need to be very, very careful on how you do that. Hold on here, I think I've got some. Thought I had. All right. The other sort of basic issue here is pre-incorporation, to make sure when the founders come on board that they, and we talked a little bit about this before, that they assign over all company IP to the company. And there's an agreement, there's a standard agreement under which they do that. Usually the IP that a founder has developed prior to formation of the company is the consideration they use to buy their stock. Founder A will contribute all code software related to the company's product that has been developed by them in exchange for shares. We talked about making sure that these agreements have confidentiality language in them. This is all part of the formation process. And IP at this stage should be defined very, very broadly. Even if you don't have code, and let's say you have a business plan or you have a concept, you want to capture everything so that when an investor looking at this after the fact is considering an investment, there's no question of whether or not you forgot to include some IP. So we like to include very, very broad language. This slide provides an overview of what the different types of intellectual property rights are. So depending upon the right, you have to take different actions to protect those rights. So trademark, I'm sure everyone's familiar with trademark, but that provides the right to use a particular mark or logo or slogan to promote the company to consumers or customers. Copyright is the literal expression, the literal words or image. So it prevents people from copying your developed copyright work. Trade secrets are information that has economic value, but you only get to assert trade secret rights as long as you keep it private. For example, the formula to Coca-Cola isn't patented, it isn't copyrighted, it's a trade secret. It's in a vault somewhere and no one has actual access to it. Other rights are contracts and NDAs. I'm sure everyone is familiar with an NDA. You can have somebody agree to keep information confidential and to use information only in a certain way. And then the last thing here is patent rights, which protect innovations. And patents are a negative right. A negative right to prevent others from using your invention, but they are public, unlike a trade secret. And patents have certain limited lives and so forth, whereas trade secrets can last indefinite as long as they're kept secret. This slide provides an overview of how you would protect IP. As I mentioned, any clouds or any question around title to who owns the IP will have the potential to negatively affect the value of the company. So invention assignment agreements from founders, non-disclosure agreements, and IP licenses with appropriate protections are all things that you should use. This is an issue that surprisingly comes up quite a bit. I had a client, a very, very large client that ultimately ended up being sold for multiple billions of dollars. And when they did their first financing round for a couple $100 million, so they were a fast growing company. They didn't have any investors in the company until that point in time. And at the time of their first financing, the investor started doing due diligence, and they noticed that of the hundreds of employees they had developing software, none of them had signed an invention assignment agreement. So the financing sort of ground to a halt. And the company was forced to go back to all of its employees in the middle of this very, very monumental financing and request that they sign a new IP assignment agreement, assigning all IP that they had created and all future IP to the company. Now, obviously, there were a lot of questions. It was quite disruptive. You had some employees say, well, what are you going to give me to sign this? So, one of the, basic lessons here is, for every new employee, develop a process to have them, in addition to an offer letter, have them sign an invention assignment agreement. All right, that's IP protection, early stage IP protection. We talked a little bit about this, breaches of obligations owed to an employee's former employer. The most basic of these are sort of IP restrictions, i.e. we talked about developing IP while you're working for an employer and making sure that there's no conflict between the invention assignment agreement you may have signed for them versus the IP you want to use for your new company. But there's also other things. Not so much in California, but some other states have what are called non-compete agreements. In California, non-compete agreements aren't enforceable as a matter of law, other than, this is an exception, other than if you sell your company and you're an executive, the buyer can make you sign a non-compete. But as a rank and file employee, non-compete agreements in California are not enforceable. But there are other things that get employers pretty close to that. And those include confidentiality agreements. You can't use any confidential information that the employer has provided you. Non-solicit agreements. Non-solicit agreements, which means you cannot, after you've left the company, go and solicit the employees of your former employer. Sometimes it also extends to consultants or vendors. And then there are common law duties. Common law always refers to sort of case law. And one of them is that you owe a duty of loyalty to your employer, to act in their best interests. You're part of the family. You can't then betray them. Doesn't mean you can't start a business. That has been established in California. You can work for an employer and start another business, even a competing business, but you cannot do so wrongly. You can't do so by soliciting customers, using confidential information and so forth, or using company IP. Okay. Okay, so this is I'm gonna pause for just 1 second here. I'm gonna close the door because I'm getting some background noise. Can you guys hear me okay? All right. So, number 4, make sure your capitalization and equity structure is standard and not complicated. I cannot emphasize this one enough. Both from a investor perspective and from a cost perspective, a legal cost perspective, because it is oftentimes early stage companies come to us with either complicated capitalization structures or situations that need to be cleaned up. And that is both can raise issues with investors, but it's also very expensive for companies to fix. So what is standard? Keep it simple and conventional. Document, make sure that all the equity issuances that you've given are documented with written agreements. There are many times that I've been involved with situations where founders have promised equity via email or orally to different contributors, which can create a lot of issues and ambiguity around what exactly is the capitalization of the company, and require kind of going back to these people to try and clarify and get them to agree that they own X when they think they own Y of the company. Here's some of the things that you should think about, though, when you're trying to raise capital. One is understand the impact of future dilution. How does a convertible note or SAFE impact dilution compared to a priced financing round? Understand what you actually need the cash for and what your next milestone is, because at that next milestone, you're going to go out to investors and try and raise capital. So what are the milestones that make the most sense that will optimize your ability to raise capital at that time? And that would include, hiring. That would include things like legal costs and so forth. So all of that sort of impacts, how much money you're going to be raising. All right. One of the key issues, and probably self-evident, is the allocation of initial equity, where there are multiple founders, and there usually are. How should the equity be allocated? This is a key issue. Logically, although this is more often than not the case, logically, all founders are not equal. You should look at what each founder is contributing and what they're expected to contribute going forward. One of the things that an investor told me is that he was looking at a very promising company that had 6 founders, but all of them had exactly the same amount of equity, even though not all of them were going to be contributing the same amount to the company. This investor ended up passing on the investment and believed that even though they really liked the company and its prospects and its technology, they felt that the founder ownership structure made the company, created a big issue for the company going forward. So that's really, a key issue to sort of nail down early. We talked before about what should be contributed for your stock. Oftentimes it's intellectual property that the founders are contributing. That value has to equal the value of the stock, or there's tax risk. We talked a little bit about that. And also the concept of off-cap table equity, promises of stock option or stock to friends, advisors, so forth, in emails or in orally. These can create real issues in a financing when these people come out of the woodwork and ask for more equity, or there's a disagreement about what the equity should be. Any issuance of stock, be it to investors, be it to founders, be it to employees, has to comply with the securities laws. So in the United States, to offer and sell securities, i.e. stock, is a security, options are a security. You either have to register the security, i.e. like a public company, or as all startups do, have an exemption for registration. And there are different types of registration. There are exemptions to issue shares to investors, which are usually pretty easy to satisfy. And then there's also exemptions for issuing shares to employees and others who provide service to the company. The general sort of philosophic basis of the securities law, of the securities laws when it comes to exemptions is either you're sophisticated and you understand what's going on with the company and investments, or you're not sophisticated, but you're wealthy and you can afford to lose your investment. And that's the general sort of basis under which a lot of the securities exemptions are organized. Okay, this is another related to what we talked about before with respect to equity. Extremely important early on to establish good terms with your co-founders and make sure the terms are customary. It's only going to be you and your co-founders when you first start the company, so you can agree to put in place all sorts of things that would be very, very founder favorable. What types of things? Well, you could say, if I get terminated, I want full acceleration of all my equity, no matter what. I want to have 100x voting stock. I want to require that anyone who we sell shares to agrees to give me a voting proxy in exchange for their shares, meaning they get the right to vote. And another one that I came across was, well, I'm contributing my IP to the company in exchange for stock, but I'm only going to do that in a license. And that if the company goes under, I want to take the IP back. That's one that I've seen before. And that is, a very fast way to make your company not fundable from an investor's perspective. So these two things from the founders keeping things standard. One is the concept that investors are looking for straightforward, especially with early stage companies, straightforward capital and founder structures. The second one is it reflects on the founders. Are these founders going to be easy to work with? Are they more concerned about downside protection if things go south than they are about the opportunity for upside? So I mentioned that at a high level. What are sort of standard agreements among founders? So how many of you, I don't know how we're going to do this on a Zoom, but how many of you are familiar with vesting of stock? I guess I'm not getting everyone's on mute, no one's talking. Anyone familiar with vesting of stock? All right, Thomas, thank you. All right, well, it is extremely standard when you're issued founder stock that the shares you get have to be earned over time, meaning you get the shares on day one, but those shares are subject to repurchase at cost by the company over what is called a vesting period. And that vesting period lapses. Typically it's 4 years. Sometimes it's monthly. Oftentimes 25% of the shares would vest on the first year and thereafter it would be monthly. But that is to incentivize founders to remain with the company and continue to provide services. It's also in the event that a founder leaves the company, if you didn't have this vesting, they would take their entire ownership share. And that would be extremely expensive for the other founders to make up in terms of hiring somebody else to come on board. It also could render the company very difficult to fund. So this vesting concept is important if you've got multiple founders, and every VC and seed investor is going to require that the founders are subject to vesting. The thing you want to avoid here, as pointed out on the slide, is the free rider problem, where somebody has fully vested stock early on, so they could leave the company the next day and they still own their 25 to 30 to 50% of the company. There is some downside protection that I think that most founders can ask for reasonably and not appear to be overreaching. So if the company, for instance, if the founder were terminated without cause, or if there was an acquisition of the company and then the founder was terminated without cause, I think it is reasonable to ask for some acceleration of your equity. And I think as a practical matter, most founders aren't actually functionally able to be fired without their consent for a couple of years. Usually it's when the board composition of the board has changed, when founders are no longer in control of the board. So, I think some acceleration of vesting is okay, but I advise founders to be measured. You can do whatever you want when you form the company, but at some point, investors are going to look at what you put in place and make an assessment. Other things that we advise founders to think about are restrictions on transfers of the shares to control who gets on your cap table. Rights of first refusal on vested shares, meaning that if a founder wants to sell their shares to a third party, the company has a right to buy those shares at the same terms. And then we talked a little bit about proxies before, but oftentimes some founders require voting agreements. The most famous of which is Mark Zuckerberg. And he got voting agreements from a lot of his investors. And ended up, as a result, controlling the company for a long, long time. The bottom line is founders are like spouses. You're going to be living with them for a long time through ups and downs. It is often not an easy thing easy relationship. So I highly recommend choosing your founders carefully. Most investors, believe that the founders are one of the, if not the most important factor of whether or not it's deciding to invest in a company. So it just sort of speaks to that. This is the other thing that I think, especially if you're developing a product in the enterprise software space or even a consumer space, you should think about putting in place before you launch, at least at the time you launch, and that is terms of service and privacy policy. Terms of service oftentimes are click-through agreements that set forth the terms and condition of what your company's service or website will like. If you go to Airbnb.com and you click on the site, you're signing up to their terms of service, and if you were to ever click through that, most people don't read the company's terms of service. You would see that's the contract under which they agree to provide you services and so forth. So that's a critical document. It also, I would say, is one that needs to evolve with the company because it defines the business model. It really defines the business model of what you're doing. And there are all sorts of different terms of service. Oftentimes early stage companies, especially those in beta, will crib off of the terms of service of a company that's analogous to theirs. And that, we don't advise that, but that's fine early on. But when you launch beyond beta and start to scale, we highly recommend that you get a custom terms of service done by a competent law firm, lawyers who has a lot of experience looking at thousands of these. The other document that's critical, especially now and especially in California, is the privacy policy. California has enacted some of the world's strictest privacy requirements. This is a priority both among states and at the federal level, and can have big consequences to the company. So privacy policies and terms of service go hand in hand. So those are the two things that not maybe when you're in development, but when you start offering your goods or services to the public, that's the time to have this set up in place. Big issue, and certainly over the long term. As the founders, the CEO, your main job is going to be hiring a talented team. This is the thing that's going to take the company to the top, hiring and retaining employees. And I probably don't need to tell you all, you are living in one of the most competitive environments for recruiting employees in the world, in San Francisco, Silicon Valley. It is one of the most important things. And the companies that are good at this and hiring top talent are the ones who succeed. John Doerr once said that his number one job as a venture capitalist is in helping his portfolio companies recruit talented employees. And unlike anywhere else in the country or in the world for that matter, one of the keys to recruiting employees, I would call it table stakes almost, is granting equity to employees. Almost every employee in the Silicon Valley expects to get some equity. And this usually takes the form of stock options. And stock options are rights granted to employees to purchase common stock at the fair market value on the date you grant the option. There are several tricky legal and tax requirements around granting stock options that clients have to be careful of. I've had more than a few that have tripped up on these requirements, some of which can be pretty significant and difficult to fix. But the basic features of these types of instruments are, like the founders, there is vesting based on continued service. The options have to have an exercise price equal to the fair market value on the date of grant. And there's a whole process for determining fair market value that boards need to adhere to. One of the key benefits of a stock option, of course, is that you give this employee this option and they don't need to make an investment decision in the security. They can wait to exercise and see if the company is going to be worth taking the investment risk. The other benefit for the company is that if the employee doesn't work out, of course, and is let go, the employee doesn't get significant equity. So this is sort of this sort of standard instrument that is granted to employees in technology companies. I could talk for hours about this and the technical details and go down a level, but perhaps for another time, unless somebody has a specific question about stock options. The other key issue we see quite a bit with startups, and it is usually flies under the radar for early stage companies, and so it's not a practical issue, is employee classification. This is whether you classify somebody who's providing a company services as an employee or as a contractor. This was the big fight that Uber and Lyft were in litigation over, that was recently settled by the proposition that passed, Proposition 22. But as effectively, whether or not a service provider is an employee and thus has to comply with minimum wage and worker compensation and entitled to benefits, or is an independent contractor and can be paid whatever without any benefits, is not a question of what the parties agree to. It is a question of facts and circumstances. And quite often, individuals who are classified as independent contractors are in fact employees. Here are some of the factors that are on this slide as to whether or not somebody validly qualifies as an independent contractor. It focuses on the degree of control exercised by the employer, the extent to which the contractor's duty are core to the company's business. If you fail to properly classify, so let's say you've classified several employees as independent contractors because you don't want to pay withholding tax or Social Security, but it turns out you're wrong. The consequence is this, is that the company then has tax liability to the state and can be subject to penalties and fines. How does this come up? Usually comes up through a employee development department audit of your company as a result of a disgruntled, quote, independent contractor being terminated and seeking unemployment benefits. And so that they go to the unemployment department and file for unemployment, and you get notified, and the company says they're not an employee, they were an independent contractor. And that sort of kicks off, can kick off an audit. I've been involved in several of these for clients, and usually the practice goes on for a while where companies end up having, many individuals who they've classified as independent contractors. At the time, it really, it becomes a problem and they get audited. And so this is one just to, as I said early on, probably not a practical issue, even though it might be a legal issue, but I would not let this, I would not have a ton of people you've classified as independent contractors unless you're really sure that you're on the right side of that issue. Okay. We talked a little bit about this before, about keeping your capitalization structure simple and not creating a lot of complexity. That's a reoccurring theme throughout all of these. Early on, keep it simple so investors can easily understand and say, okay, this company is a standard company. These founders know what they're doing. But I put this slide in here around founder control because over the last 10 years, founder controlled devices have become a very, very hot topic. And it's quite often when I meet with new founders, one of the first things they ask about is, well, I don't want to lose control of my company, and I want you to put in place devices that will ensure that I can't lose control. And what I tell them is we can do that. It will raise issues with investors. But the best thing you can do to maintain control is, as I said before, be capital efficient. If your company doesn't need to raise a lot of money and is successful on less capital, you'll be able to call the shots as the founder. That's what happened with Facebook. That's what happened with Airbnb. That's the main thing I say to founders about this issue. But what are some of those control devices? So we've talked about dual and superclass voting stock, and that is shares that have more than one vote per share, where you issue the founder's Class B stock, which has 10 to 1 or 20 to 1 or even 100 to 1 stock, and you issue everyone else Class A common stock, which has 1 vote per share. Economically, one share of Class A and one share of Class B stock are the same. They're economically the same. They represent the same amount of ownership in the company. But from a voting perspective, they're not the same. So that's one device. Investors who come into a company that has a dual class structure oftentimes will say, that's fine, you can keep that, but we want the dual class too. So it's very unusual that founders are able to keep dual class voting stock just to themselves. The other, another device is multiple director votes. Under Delaware law, which is one of the, so we typically advise companies to incorporate in Delaware. Most venture-backed companies are Delaware corporations. But under Delaware law, it is permissible for a board member to have more than one vote on the board of directors. So let me step back here. Corporations are owned by stockholders who elect the board. The board manages the company. The board approves all the major decisions that need to be made of the corporation. The stockholders only have say over a couple major things, such as sale of the company, such as amending the charter to authorize more shares, and as I mentioned, electing directors and removing directors. Directors, on the other hand, approve everything else, including hiring executives, the CEO, and so forth. So the board is key when it comes to who runs the company, the day-to-day operations of the company. And one of the things that's permitted under Delaware law is that a given director or directors can have multiple votes on the board. So you can have, founders can have, 2 or 3 votes for their one director seat. That's unusual. It's going to raise eyebrows. You're going to get a question from, investors about it, but it is a control device that we've seen. Restrictions on transfers of shares. We talked about this. We now recommend to most of our startup companies that they adopt some form of transfer restrictions so that a shareholder, if they want to transfer stock to another party who's not an existing shareholder or who's not a family member, there's certain exceptions to these restrictions, mainly for family members. They have to get the approval of the board to do that while the company is private. And the reason for that is to control the composition of the cap table and also to limit the number of shareholders on your cap table. The other device that is more common is stockholder voting agreements, and these are basically voting agreements among the founders to vote their shares in a certain way. So I'll just pause there for a second. I know I'm moving kind of fast here, but wanted to, so there's a fair amount to cover. The initial board composition, when you first form the company, it's very typical that the board would only consist of founders. As you raise money, investors will ask for a board seat. As I mentioned, as a control matter, the board is critical. It is something that you should pay attention to, but it should also be viewed as a resource to the founders. So you want people on the board who are going to add value if they're not founders. And so making sure who's on your board is an important question. And that also relates to who you have as an investor as well. At a high, again, the same issue, keep the governance simple. Special rights or voting arrangements, multiple votes, can create issues down the road. And so you want to be mindful about that. All the things we've talked about sort of roll up to this one thing, this one concept, which is properly structuring your first round of funding. So you're going to go out and raise a first round of funding. More often than not these days, that's either going to be a SAFE or a convertible note. I assume most of you are familiar with what those are. Those aren't actually priced financing instruments like a share of stock. You actually have to ascribe a value to. With a SAFE or a convertible note, there is no value. Those instruments convert when you do your first priced round at the value established by investors in that first price round. So most startups will raise a convertible note or SAFE round between 500,000 to $1 million, $1.5 million or so to get going. They'll use that money to position themselves for their first price round 6 months to a year down the road after they've hit some key metric. And determining, as I talked about before, what that metric is going to be key. So it should be informed of what investors are looking for, and actually executing on that will be key. We talked about convertible notes, which are not priced. There's no valuation. Convertible note is debt. Basically, investors loan you the money, but that will convert into stock when you do your first preferred stock price round. The SAFE is very similar to a convertible note. It's not a value, there's no valuation attached to it. Although most convertible notes and SAFEs have what's called a valuation cap, meaning that if whatever you raise your next round at, the highest valuation that the note or the SAFE will convert at will be X. Now, for seed round financings, for early stage first financings of companies, the caps are usually between $5 and $10 million. So that means that if you're raising a round at $20 million for your first price round, these notes will convert as if the valuation was $5 or $10 million. And the reason for that is they're taking the risk early on for investing in your company when others were not willing to do a price round. There's a lot of terms around this, and I have a separate presentation just on convertible notes and SAFEs and seed financings. The other early type of financing is what's called a series seed round, which is an actual priced round. The series seed round usually is for more money than these note or SAFE rounds, although it doesn't have to be. But they do require you issue preferred stock and that you value the company. You actually have to come up with a valuation. the beauty of a convertible note or safe is you don't need to value the company. That's for the future when you do a price round. And oftentimes with very early stage companies that are still in development, it's very hard to value the company. The one thing I would say is when you're raising, I have a few early stage clients who have made the mistake of raising capital by issuing common stock, which is what the founders are issued and what employees are issued. You don't want to do that because, believe it or not, you want to keep your common stock for employees and founders and leave your preferred stock for investors. You want to set a differentiation between the two values. You want to keep your common stock actually valued low, so employees get cheap stock that has a lot of upside, but you want to sell your preferred stock at what is the quote true value of the shares to investors. All right, this is sort of the recap of what we just talked about. One, failure to form your legal entity or the right legal entity for your startup, making sure that the company owns all the IP, be careful about breaching obligations to your former employer, or making sure that you have a clean break from your former employer, making sure that your equity structure is standard and simple. Make sure you establish clear terms in writing with your co-founders. You put in place appropriate terms of service and privacy policies at the right time. I'm not saying you need to do that right off the bat. Focus on recruiting quality employees. That's going to be key in creating a culture where people thrive. Again, I know this may sound redundant. Avoid creating too much complexity or structural issues around control, and properly structure your first round of funding. We can do another series on that last one, but that's what I've got. I'm happy to answer any questions that people might have. Or you can email me.
Yeah, I got a question from a student here, and he's asking, when is a good time for early stage startups to come to get an attorney or an advisor on board regarding the legal issues?
Yeah, I think so. I think it's when you're ready to form the company. That's what I think. Now, there are a lot of different services out there where you can form your own company. You can incorporate the company in Delaware, and they have sort of standard certificates and bylaws, and that's fine. I'm for that. I think it gets a little bit trickier when you start to issue shares to the founders, because you're going to want to impose vesting on those shares, especially if there are multiple founders. If there's a single founder, it's easy, no vesting, all fully vested. But if you have multiple founders or you have employees, that's the time I think you want to start to talk with an attorney and make sure that you're getting, the right advice. And a lot of, Fenwick included and me included, we'll early on, we have special programs for startups. There's also incubators and accelerators. I'm sure you guys are familiar at Berkeley with that. They oftentimes have a lot of resources for starting and forming companies that can be extremely helpful. But I would say, my view of this is early on, I've had companies that haven't used lawyers and have come very late in the game to us where they've actually been conducting business for a long time, and it can be quite expensive to try and clean things up, and usually, so you want to avoid that situation.
Great. And then a second question is that, does anything changes from your perspective when company go from private to IPOs?
Oh, yes, immense changes. So it's almost like you're in a different reality. And I think what happens over time is as the company scales, the profile of what your job is as a founder will change. Not everyone likes being a CEO of a large, even a large private company unicorn can be a very different thing than being a CEO of a 10-person startup. Companies, but you're dealing with a lot of different things. So if you're an entrepreneur who likes focusing on development, and if you remain as a CEO of a large company, you're not going to be doing a lot of development. I can tell you that, because the CEO's job of a large company is very, very different than the CEO's job of an early stage startup. So there are 1,000 things that change. The legal, administrative, managerial requirements all are amplified as you get larger, right? Because you have now many more employees to manage, you have many more customers to deal with, you have more complicated legal issues to deal with, and so forth.
Right. And another question is that how do VCs come up with their evaluation for companies?
Yeah, it's a really, really good question. Most of the time, there's sort of a standard sort of expectation on valuations for certain types of companies at certain stages. The earlier stage the company is at, the less objective valuation is, right? There are less market comps. The most objective, I would say, would be IPO, right? You can look at public company comparables and compare them to what your company, is doing at that, in that space, and use those multiples. But as you move earlier down the stack in terms of private companies, the more variable and subjective valuation gets. I would say, as I mentioned early on, early stage companies that are raising their first round of funding, it's all by sort of, well, you're just raising your first round of funding. Either we're going to do a convertible note with a sort of typical cap on valuation, which doesn't set a valuation. Or if you want to do a priced round, we're going to do what we do for all companies in that, at that stage, $5 million pre-money, $10 million pre-money valuation. So it's very, I would say, formulaic, but divorced from the actual company. Now, there are exceptions to this if your company actually has an operating business, is generating revenue, and has real customers. And then you're sort of in your own rarefied atmosphere. And then you can use comps from more mature companies to try and set valuation. So that's what I would say there. I would also say that if you're a company that is getting a lot of traction and you get a lot of interest from multiple investors, so you have a lot of demand on the investor side, that can, for lack of a better term, distort the valuation question and can result in very, very favorable valuations for the startup, because you're a hot commodity among investors who want to get in on the investment.
Yeah, I actually have a question about patent and IP. So I've always heard that it's a very complex and very, I guess, time-consuming process. Is that true? And also, what happens if there's two very similar products or softwares? How do you differentiate the patents with, for both of them?
Yeah, I think Summer, the first question is, what type of IP protection, patent, copyright, trade secret, trademark, confidentiality agreement, is best suited for the type of technology or innovation that's at issue? And is it worth the cost that it will entail to get that protection versus the value, of that particular IP? So for instance, I had a client today that operates a consumer platform company that's offering services, marketplace company, early stage to consumers. And she asked the question, and it's, that company, their IP is principally their website and their marketplace software. You know, should we patent our software? And my view of that with software in particular and patent work is that there's really not a great cost benefit to patenting software, depending on the space. Now I would exclude IP, AI. There's certain types of deep AI applications that can be very valuable. But generally speaking, software is not, you're not going to get a whole bang for your buck in terms of patenting. Most investors aren't going to care whether or not you have software patented or not. And patents in particular over time, because filing the initial provisional patent is relatively cheap, but over time can be very, very expensive because you have to prosecute the patent. And so I would say that the first question is what is the particular IP innovation you're speaking about? How is it strategically important to your company? How integral is it going to be? And is it cost effective to protect it one way versus another?
There is another question asking, like, where do founders usually end up when they step down for the position, or if they leave the company? Do they become a advisor or on the board or anything like that?
Yeah, it's a good question. Oftentimes, so being able to transition as a founder, I would say, can be a very hard thing to do. And oftentimes it comes about as a result of the first question you asked, is like, how is the company very different from a startup and an IPO? Is that the company becomes a very, very different enterprise and skill set of a founder who might be a tremendous CEO for a Series A or Series B company, but for a multi-billion-dollar enterprise software company just doesn't have the skill set. That can be a very, very hard transition emotionally for founders to make. And so I admire founders who are mature enough to make that and transition for the good of the company. Where they end up is there's a lot of variability in that. I mean, sometimes they end up still at the company, serving on the board and in some other position like CTO or some other development group's chief of product and so forth. So that is a common. They can also, as I think the questioner asked, they can also end up as an advisor to the company and go on to do other things. It's not uncommon for them to go off and start a new business. I represent a couple former founders of very large, successful businesses. So all of those things are possible. Oftentimes the founder will remain on the board, but end up doing other things.
Great. And I guess a follow-up question would be, what are some common traits that you've seen among the founders that you've worked with?
Yeah, so that's a great question. So I think the one, and I did a panel years ago at Berkeley at the Lester Center, where we had a panel of VCs answer questions about entrepreneurship and startups and founders. And one of the investors there was a guy named Joe Kraus, who's the founder of Excite, among other things. He's now at Google. And he gave a great story, and this, believe it or not, this gets to your question at some point. He gave a great story about Vinod Khosla when Vinod Khosla was at Sun. And I think it's actually part of a Harvard Business School study, but the gist of it is that one of the most important traits of a founder is persistence. It's, you know, of all the different things, it's the ability to continue to move forward, even though there are ups and downs, and there will be downs. And so being able to, I think in the face of failure, figure out, think how to move forward and continue to push ahead. It is inevitable, almost inevitable, that whatever you come up with early on as your idea or your startup, it is inevitable that you're going to have to change, that you will hit some roadblock, that the product you thought consumers wanted is not quite what consumers want, or the market is different, or the features need to be changed. I represent a company, a YC company back in the day this is my favorite story about this concept. That was a social dining company. So it was a company called Grub With Us. And what they did, they had an app where I could have a dinner at a restaurant, and it would say, Sam Angus is having this dinner, please, come. And so people would sign up who I didn't know, total strangers, and it would have your bio, and you would get there, and it would be a way to socialize. Well, great idea, didn't get any traction. They raised a reasonable amount of money. They ran it for about 5 years, and then, things quieted down. I was their lawyer. I didn't hear from them for about 1.5 years. And then I got a call from one of the founders saying, hey, we've started something new and we've pivoted and this thing looks like it's taking off. Well, that company is a company now called Goat, which sells tennis shoes. And so they're a platform for sneakers, and they've exploded. So that just sort of tells you about persistence, about embracing change, and about being flexible. So I would say that being flexible and being persistent are the traits that I see the most in successful entrepreneurs.
Great. And I have a follow-up question. It's what happens when a company, I guess when founders decide to shut down a company? Do they just turn in all the paperwork and stuff?
Well, so as a legal matter, if the company sort of runs out a runway, depends on the sort of financial condition of the company. As a legal matter, creditors get the assets of the company. So that would include cash, IP, equipment, whatever you have. Sometimes there's a bank that might have priority among creditors to get the assets. After the creditors are satisfied, or if they can't be satisfied, to the full extent of the assets, then the company is wound up and dissolved. The equity holders, the stockholders, are last in line. It is unusual in the Silicon Valley for private companies to go through a bankruptcy and try and reorganize their debts and emerge from bankruptcy with new financing. It's happened. It's highly unusual. Most of the time, if a company is going under, they will pay their creditors, return any remaining capital to their investors who have sort of first dibs, and then dissolve the company. And there's a process under Delaware law for dissolving your company, and under the law of any state for dissolving the company, and that's the end of it. We move on.
Great. That's all the questions I got from my end.
Great.
Yeah. With that, I guess that would be the end of the class today. Thank you again for coming in. It was really informative.
Great.
Yeah. Thanks for being here.
My pleasure. Thanks for having me.
Did you say we could email you? Like, do you have any contact info?
Yeah, there's my contact info. I should have put that up. And I think Thomas, do you have the slides?
Your slides?
Yeah, I can send them to you, and I don't know,
Yeah,
maybe you
sure,
could
sure.
send them.
Yeah, I
send them-
don't have it yet, but I can upload it if you can send it to me.
Can you send me your email? And
Sure, great.
and then I'll just email it to you, and then you can, for people who want it, you can send it around to the class.
Yeah, great.
Great. Thanks again.
Yeah, thank you so much.
Thank you.
You.
Okay.